my learned friend, colleague Mr. Sinha will take care of the major issue the Honourable Member has raised. SICA will eventually go. That's the first. Sarfazi will have to be amended and brought in line with the change provisions of the bankruptcy law. There are some changes which are required to be done. I have introduced those changes in the Lok Sabha today, and that I have had it referred to the joint committee, and that is why I insisted that the same joint committee should look at it, because they've dealt with this act. As far as DRT is concerned, there is a jurisdiction that DRT will have, because the appellate jurisdiction, the jurisdiction with regard to insolvency will be with the company law tribunals which are created for that purpose. DRT will remain with regard to recovery proceedings, and with regard to those individual insolvencies, the DRTs would have jurisdiction. Now, the problem with DRTs is that there is an inadequate infrastructure. It almost functions like a civil court, takes a lot more time. So today, to the DRT legislation also, I have introduced amendments in the Lok Sabha, referred to the same committee, and the entire procedure of DRT also is being altered. And in the altered position, a large part of the DRT proceedings will now go online, so that there will be limited hearings itself. Now, with regard to your last query, with how is it comparable to the Chapter 11, Jayantwal?
Okay. Thinking of a 5-year time frame?
No, it will be phased out immediately.
Okay.
There will be a period given under which the SICA complaint will have to be brought before this new forum.
So the SICA cases will automatically transmit themselves into the new mechanism. Is that the process that you are contemplating?
And one of the differences between your Chapter 11 is that in Chapter 11, the debtor continues to be in possession. Here, the creditors will be in possession. Now, SICA being phased out, and I'll tell you one of the reasons why SICA didn't function. Under SICA, the predominant experience has been, and that is why a decision was taken way back in 2002 to repeal SICA when the original company law amendments were passed. Now, since they were challenged before the Supreme Court, it didn't come into operation. Now, the object behind SICA was revival of sick companies. Now, not too many revivals took place. But what happened in the process was that the protective wall which was created under SICA, that once you enter the BIFR, nobody can recover money from you. So that non-performing investment became more non-performing because the companies were not being revived, and the banks were also unable to pursue any demand as far as those sick companies are concerned. And therefore, SICA runs contrary to this whole concept of exit, that if a particular management is not in a position to run a company, then instead of the company closing down under this management, a more liquid and a professional management must come and then save this company. That's the whole object. And if nobody can save it, rather than allow it to be squandered, then the assets must be distributed, and as the select committee joint committee has decided, distributed in accordance with the waterfall mechanism which they have created.
Okay, now